Yes.
My ladies, my lord, my name is Latham. I appear on behalf of the appellant in this matter with Mr. Buchan, who sits behind me.
Yes. And somebody else behind you as well?
Mr. Buchan's pupil.
Right. And the name?
Forgive me.
Adam Pennylock, madam.
Thank you very much indeed. Yes, Mr. Latham.
Thank you. Mr. Malaloo, King's Counsel, appears on behalf
Yes,
of
indeed.
My ladies, my lord, for the purposes of this appeal, it's important for me to address one point about the scope of the appeal at the outset. For present purposes, this claim may be split into three distinct periods. The first period is prior to the defendant's application to amend the dated the 6th of May 2021.
Yes.
The second period is after that application is made, but up to the date one day before trial, which is when the claimant's Part 36 offer expired. And the third period is the trial itself, the 2 days of the trial, the 19th and 20th of April 2022. The claimant's Part 36 offer was bettered at trial. The claimant did better than, the claimants, I should say, did better than their Part 36 offer.
So it was beaten?
It was beaten. And so by automatic operation of Part 36.17, the claimants were entitled to their costs on the indemnity basis for the 2 days of the trial. That was agreed.
So that was the basis. It's my fault I hadn't picked that up. The basis for the indemnity decision from the 18th of April was because of the Part 36 offer.
That's correct, my lady, right. Yes.
Had you picked that up? No. Had you picked that up? No. Why haven't we picked that up?
If it would assist, I can
That's in the papers somewhere.
It is. If I... it's in the transcript of the submissions before the trial judge.
Right.
If your ladyship will forgive me one moment, I'll take...
Yes, please. If it helps you all, we are familiar with the papers. We've certainly read the skeleton arguments very carefully on this.
I'm very grateful.
Tab 11, pages 110 to 115.
Yes.
114, if it helps.
Thank you very much.
It is at the bottom of page 114.
Right, so those instructing me made a Part 36 offer for the trial of 27.5. So my learned friend has agreed the claimant's costs to be on a normal basis up to 21 days and thereafter. So that was the basis of the indemnity costs concession.
Indeed.
I see. Thank you very much.
So it wasn't the exercise of a discretion or even a concession made on that basis, that the circumstances were such that the order should be made. It was by automatic operation of Part 36.17.
Thank you. And then before 6th of May 2021,
yes,
it was conceded should be on the standard basis.
It was.
And you don't seek to resolve from that?
I don't.
No. Why was that not mentioned in your application for permission?
I can only apologise that it was.
It should have been, shouldn't it?
It should have been.
Because it does wipe out all of the submissions relating to pre-6th of May conduct?
I make it slightly more nuanced than that, my lady. The conduct prior to the 6th of May 2021 is contextual and informs what happens thereafter.
Right.
So, for example, one of the areas of concern, if I put it that way, is the independent, or rather the field investigator, as he's described, attending Mr. Patel, the independent witness.
Right.
That happened before the 6th of May, of course, but the application to amend the defence was based predominantly upon what that investigator had, or the conclusions that he'd drawn, and subsequently a witness statement was prepared on behalf of that investigator, and he attended trial to be cross-examined, if appropriate, on the discussions he'd had with Mr. Patel.
Okay, so we've got these three separate periods to consider.
Yes.
Thank you.
And really, for the purposes of this appeal, only one period I invite you to consider, which is the period post the application of the 6th of May 2021.
Mm-hmm. To the 18th of April.
To the 18th of April 22, that's right. Excuse me. Turning then to the trial judge's decision, My learned friend's skeleton argument agrees the factual summary as it's set out in paragraph 4 of the appellant skeleton argument. But there are two particular points I wish to highlight. And the first goes to the field investigator's attendance on Mr. Patel on the 27th of December 2017. If I may take the court in the supplemental bundle to page 239.
What are you doing at this stage? Would you just sort of signpost where you are? You taking us to some facts you want to highlight?
Yes, there are two facts I want to highlight. The first is in relation to the interactions with Mr. Patel and how he categorises that in his witness statement.
So page?
Page 239.
Thank you.
Paragraph 18, which starts in the middle of the page. He begins to explain that having given a witness statement to the claimant solicitors, he hadn't heard anything for some time. Then explains that he received the first telephone call from Mr. Ferguson, the defendant's insurer's investigator, that he was driving at the time and that he asked Mr. Ferguson to call him back the next day after midday. You'll see at the bottom of page 239, the investigator at that stage gave what he described as a warning that the investigator had spoken to the witness's uncle and that the uncle had told the investigator that the driver of the BMW, the claimant, first claimant, was a friend of the independent witnesses. Mr. Patel, the witness, informed Mr. Ferguson that that wasn't true immediately. That's at the top of page 240. And that he didn't know anybody involved in the litigation and that his uncle must have been confused. Interestingly, at that stage, the investigator suggested that it would be necessary to obtain phone records to verify that there was no link or communication between the first claimant and the witness, and the witness, Mr. Patel, confirmed, yes, you can check that one.
Yep.
No worries were the words that he used. Paragraph 19 of the skeleton argument, I don't propose to take the court through this line by line, but at paragraph 19, he explains that when he got home, his uncle told him that somebody had come to the house alleging that he had committed fraud and threatening that he would be put into prison. He explains at the top of page 241 that gave rise to him being scolded at home and being embarrassed in front of his family for what he considered having done nothing wrong. He then says that there was tension at home, despite having done nothing wrong, and you'll see about halfway down the page, the line beginning with threaten my family by accusing me of possible fraud. He says that he felt totally violated by the interaction, that he'd felt intimidated, and that this amounted to...
Is this all part of your submission, that there was exceptional, or rather, so out of the norm behaviour in the relevant period because of the fraud investigator's approach?
Yes.
Right. Yep.
That's made good by a review of the transcripts of those calls. Rather unusually, there were audio recordings, and we haven't troubled the court with the audio recordings themselves. But the trial judge had the benefit of the transcripts of those audio recordings, which start on page 256 of the supplemental bundle.
Yes?
It seems to be accepted that in the second call, so this is the call after the next day, if I take the court to page 260, the bottom of that page, counting up, it starts with Big Esh, the witness, then Martin, the investigator, then Big Esh again. And Big Esh says, you shouldn't just say to him being the uncle, because I wasn't there, you shouldn't just say to him that I've committed fraud, and that's why I may have to go to prison. And interestingly and importantly for these purposes, Martin, the investigator, doesn't challenge Mr. Patel on that assertion that that's what he'd said to Mr. Patel's uncle. He says, I said there was...
No, he does challenge it. He says, I didn't say you've committed fraud. Martin says, I said there was a possibility of fraud.
He challenges him on
Yep.
whether it was an allegation as opposed to a statement that he had, a statement of fact. But he doesn't, for example, say, I didn't mention anything about prison or words to that effect. Mr. Patel's frustration is perhaps most helpfully demonstrated on page 263. 2 pages forward, still in the transcript. In the middle of the page, after Martin, the investigator, says, okay, Mr. Patel Biggish says, the person who goes to my family in the festive period and ruins my holidays and makes me in a situation where I have to face my family's anger, I don't like it. I don't appreciate it at all. That's for sure. Investigator says, yes, yes. So you're saying it's probably better that I speak to your uncle then. And that feeds into Mr. Patel's, in my respectful submission, entirely understandable concern as to the approach that the investigator had taken.
Thank you. Mr. Patel gave evidence before the judge.
He did.
Do we have a transcript of her judgment on liability?
Yes, it's the first page of the supplemental bundle.
Thank you.
Page 3.
Thank you very much. Just give me a moment.
If it's of assistance, my lady, paragraph 13 on page 6.
Thank you very much.
The judge starts turning to the evidence of Biggish Patel.
Yes.
And on this, the relevant paragraph's 24, I think.
Thank you.
I'm very grateful.
Yeah. Yeah, thank you. Thank you very much. Yes.
My lady, turning back to the transcript momentarily. Sorry, the witness statement, forgive me, page 245 of the supplemental bundle. Paragraph 25. This is important context. Mr. Patel says that he contacted the claimant's solicitors after having concluded the call with Mr. Ferguson to explain how angry he was. And then at the top of page 246, and this goes to one of the points made by the trial judge ultimately in refusing the application for indemnity costs, he explains the unnecessary trouble caused in his household and that he was seriously considering stepping aside and do not wish to interfere in other people's business. But at the same time, he said that he could not let something like this happen. He believed that he'd been threatened of going to jail, he says, for helping people involved in a car accident, and that he assures that he will go to court to ensure that something like this doesn't happen to somebody else and that they would be intimidated and victimised by the insurance company. In due course, in a moment, I'll take the court to the trial judge's conclusions on the application for indemnity costs. And one
Yes.
of the factors that she expressly takes into account is the fact that public-spirited witnesses ought not to be discouraged from assisting in these sorts of cases with threat of these sorts of allegations. The reason that I said at the outset of the hearing that this is important contextually is because this conduct carried on far after the 6th of May 2021 application, because the application itself, which is in the supplemental at page 50, supplemental bundle,
And this is what?
this is the witness statement of, forgive me, let me take the court back a few pages. Page 43.
Yeah. The witness statement of the solicitor.
That's right. So page 43 is the application to amend the defence to plead fraud.
Right.
Dishonesty.
Yep.
Starting on page 47 is the witness statement of Angela Nazran of DAC Beechcroft,
Yes.
a solicitor with conduct.
The background, the end of defence, and so the date of this statement is the
The date of the statement is, it's appended to the, or rather in support of the application, the 6th of May. In fact, it's dated the 6th of May 20.
Thank you. The page 50, paragraph 16 you want.
Yes. I'll go through this in a little more detail in a moment. but paragraph 16, Mr. Ferguson's evidence is a central part of the application to plead fraud and fundamental dishonesty. Paragraph 16 explains that the defendants aver that the alleged witness, Mr. Patel, appears to be known to the first claimant. It explains what the uncle, or rather what Mr. Ferguson says that the uncle told him. And you'll see in the final, in the middle of the paragraph says, the investigator showed this man the name of the first claimant. The man identified the first claimant as being a friend of his nephew, Mr. Bigesh Patel. And ultimately that gives rise to the conclusion of paragraph 19 made by the solicitor, which is, as such, the defendant believes there is sufficient evidence to allege that the claimants have been fraudulent with their claims, and the defendant wishes to amend the initial defence to plead fundamental dishonesty.
But did the investigator give evidence at trial?
He was there to give evidence. There was a witness statement, but at the trial judge, Her Honour Judge Backhouse, gave a fairly strong indication at the outset that she was going to attach very little weight to his evidence, which was hearsay in any event.
So there was never any finding as to whether or not what the fraud investigator said he was told by the uncle was true or not?
That's correct. The judge indicated that she would give so little weight to it that she didn't want to waste time. With that strong indication, Mr. Buchan decided not to call him to give evidence, live evidence. Sorry, not to cross-examine him, I apologise.
The trial judge seemed to have spent quite a lot of time trying to damp this down.
Yes.
She did not regard this as a state trial. She regarded it as an ordinary road traffic accident.
That is fair in this context. What the trial judge has said.
That's also true of what she said in the case management conference.
Indeed.
I mean, from every time she said something, both in that and in her final judgment, that was and indeed in her judgment on costs, that's the theme that you pick up.
Indeed, my lord, and what flows from that, in my respectful submission, is this. The defendants, forgive me, let me start one step back. Her Honour Judge Backhouse's clear view was that there was insufficient evidence to make this allegation. There was no corroborating evidence at all. She makes reference at one point in this final judgment to this claim having none of the hallmarks of this type of fraudulent claim that is before the courts all too often. And one frequently sees in this type of claim with this type of allegation social media profiles, photographs of people who are apparently independent with claimants, them being friends on social media, etc. There may be other types of link. There are often investigators' witness statements, and indeed in this case, there was a witness statement from a Miss Kimpton, which is in your supplemental bundles at page 264. I needn't take the court to that particularly, but it may be worth noting that the first sentence of that witness statement on page 264, Miss Kimpton describes herself as an intelligence researcher in the intelligence team at DAC Beechcroft. So one does see in this type of litigation where there is an allegation that the claimants have been fraudulent, where there is an allegation that there is a conspiracy to defraud the insurers, where there are allegations of fundamental dishonesty, that the insurers are well equipped to find evidence which corroborates a suspicion. In this case, the circuit judge was keen to point out that no corroborating evidence was in existence at the point at which the application was made in May 2021. And as my Lord Coulson rightly identifies, in the transcript of the exchanges at the CMC, which starts on page 20 of the supplemental bundle. Page 22, if I may take the court to that. At B, there was an exchange with Mr. Wazak, counsel for the defendants at that time, where the judge says, notwithstanding you want to plead fundamental dishonesty, you want this reallocated to the fast track, yes or no? Mr. Wazak confirms that that's his position. Judge Backhouse says, marvellous logic. Okay, application to amend. Mr. Wazak, how on earth do you come close to alleging a conspiracy? All you've got is doubts. I mean, is it the usual? Is it not? It is 3 claimants who say X, your van driver who says Y. You've got doubts about the independence of the witness. Okay, that will come out at trial. How does this get past the normal representations and cross-examination that any competent counsel on behalf of a defendant would do at trial? Why on earth is there any basis for pleading fundamental dishonesty? Not
Obviously,
deterred.
I mean, you are both well versed in the Quox regime, but the effect of succeeding on fundamental dishonesty is that the regime is disapplied, and therefore, if the defense is completely successful, is this right? It will then recover its costs, whereas under Quox, it will recover nothing.
That's right. There is a second facet to that, of course, which is that the intention behind the qualified one-way cost-shifting regime is that litigants need not take out after-the-event insurance for certain, in certain circumstances. In reality, most do, because of failure to beat a Part 36 offer can erode the damages if there's an adverse costs order. But of course, where there's a finding of fundamental dishonesty, the insurance provider, after the event legal expense insurance provider, will withdraw indemnity because there's no longer good faith in the contract. And so my lady's right that the first stage of the consequences is that Quox protection's lifted and the defendant recovers their costs. But the second part of that, the other side of that coin, is that claimants will not be insured and will bear that responsibility personally. And this court may have experience of defendants quite properly pursuing those cost orders to recover money and making claimants bankrupt if they don't have it.
Yeah.
On that point, it may be worth noting that when the case was budgeted, future costs for the defendant were approved at £71,000. Forgive me, it might be £78,000. I can check that in a moment. In any event, my point is that it's a substantial figure that the claimant would have faced by way of liability or the claimants would have faced, had the fundamental dishonesty allegation succeeded.
Yes.
While we're at the transcript of the exchanges at the CMC in July of 2021, I wonder if I might take the opportunity to draw the court's attention to 2 other things. Firstly, on page 23.
Sorry, my fault. You said July 2021. I thought the application to amend. Is that when the application to amend was heard?
That's right. The
I
6th
see. So the application was made, again, my fault.
Made on the 6th
Made on the
of
6th of
May.
May, but heard on the 16th of
16th,
July.
that's right.
Yes.
Mr. Wazak, no doubt fulfilling his instructions, persists to persuade the judge that it is an appropriate case to amend the defence. Paragraph D on page 23. He makes clear, excuse me, that the defendant's case is that the allegation is that the claimants have sought to put forward a false witness. That's Mr. Patel. And then at the top of page 24, in the same vein, the other witness, who is only known as Farid, or Farid perhaps, there is a discussion about the fact that nobody's been able to track him down since, his telephone number having run dead since the accident. Now, a paragraph at the bottom of page 24 at H. This application is on any view an application to amend the defence to plead fundamental dishonesty, but it's also clear that the allegation is that the defendants are, that the claimants have acted fraudulently. One sometimes sees a distinction trying to be drawn between those 2 allegations. In my respectful submission, that's dancing on the head of a pin. If you're fundamentally dishonest, then it's a conspiracy to defraud the defendant's insurer. But if there were any doubt about that, Mr. Wazak makes clear at the bottom of page 24, where he makes reference to the amended defence drafted by counsel, Mr. Sharp, who was trial counsel. And then in the final 3 lines, that being the defence pleads fraud, This is not a case in which fundamental dishonesty may crop up in the course of the case. This is a case which the defendant says is fundamentally dishonest from its outset, both in relation to the circumstances of the accident and in relation to the witnesses that the claimants seek to rely upon. And we would say, Your Honour, that the proper thing to do is to obtain permission in relation to the amended defence so that the defendant has fully set out their position. Not least the claimants, in response, have the opportunity to submit a reply.
Yes?
And then it goes on, it may be important, it goes on, of course, it's right that the point fundamental dishonesty can be argued as long as sufficient notice is given.
That's right. That's the authority of Howlett, which is referred to in the Skellison arguments. We haven't put that in the authorities bundle because I don't think very much turns in this case. Just going back to the application, I indicated that I would go through that in a little bit more detail. And to some extent, the submissions of Mr. Wazak already identify some of the points I wish to make. But if I may take the court to the application notice again and the witness statement in support, that is page 50. Forgive me, 48 is where it starts.
Yes?
Paragraph 9 at the bottom of page 48, under the heading amended defence. The solicitor for the defendant says that the evidence available has been reviewed thoroughly and it's now believed the claimants have conspired to knowingly and dishonestly present false evidence regarding the alleged circumstances of the collision. As such, the claimant's claims are or are tainted by...
Sorry, paragraph?
Forgive me, paragraph 9 at the very bottom of page 48 of the supplemental bundle.
That's not my paragraph 9. What am I missing? I'm looking at paragraph 9, page 48, the supplemental bundle.
Yes,
It's under the heading amended defence.
Yes. Oh, I see, got it. Thank you.
thank you. So the evidence has been reviewed thoroughly. Now believe the claimants have conspired to knowingly and dishonestly present false evidence, the top of 49, regarding the alleged circumstances of the collision. As such, the claimant's claims are or are tainted by fundamental dishonesty, and the defendant seek to rely upon the amended defence for both defendants. Paragraph 11.
Sorry, Mr. Latham, to
Yes.
interrupt. What are we looking at this for? We know the judge thinks this is all nonsense. 'Cause
Yes.
She says so.
She says
She
so.
says all you've got is a suspicion. So
Yes.
why are we looking at the rather high way in which this is put by the witness in the statement?
Well, there are 2 points that flow from it. The first is the point that my lord identifies, that in fact this is not accepted by the judge, that there's nothing in this case to corroborate more than a mere suspicion that the independent witness is not independent. The second point, and forgive me, my lord, if I'm not being very clear on this, is that the nature of the allegation is that the defendant is not sitting on the fence. They're not putting the claimant's proof. They're not even saying, well, we have some concerns about this case and we'd like to keep our powder dry for trial, in the way that Howlett perhaps anticipates, that a defendant doesn't have to nail their colours to the mast at an early stage, that the defendant can see how the evidence transpires during the course of cross-examination and then make an application accordingly, that Section 57 ought to be applied, that the claim is fundamentally dishonest, that Quox protections lifted, etc. The defendant, for want of a better phrase, goes at 100 miles an hour on this and sets out a clear allegation that the independent witness is not independent, that his evidence is dishonest and fraudulent, and that the three claimants and the witness together have conspired to defraud the defendant.
So that's the application made. It falls on barren ground. And where do we go from there?
If I may take you to Judge Backhouse's judgments, both at the CCMC and then at the end of the trial when the application for cost is made. Firstly, page 40 of the supplemental bundle, page 41. you have the judge saying at paragraph 2, the nature of the application. Then at paragraph 3, second sentence, the matters put forward, in my judgment, come nowhere near what is required to be able to plead fraud.
Yes, we
and
can
or
read that paragraph.
fundamental
That's
dishonesty.
good, thank you.
And then she says at the end of that paragraph that this is absolutely standard. The reason that's important is because the defendant wasn't deterred by that. The defendant had been given a very clear indication more than a year before, almost a year before trial, that their evidence was insufficient to even substantiate the pleading. That's important because by the time we get to a trial, nothing has changed. The defendant maintains this allegation of fraud against both the claimants and the witness, and they maintain it without any corroborating evidence at all beyond the witness statement of Mr. Ferguson, which
But you
simply...
got your costs on an indemnity basis at trial.
Yes, but the allegation had never been dropped. That was the nature of the defendant's case throughout. And that continued from the moment in 2017, on the 27th of December, when the investigator took the heavy-handed approach that he did with Mr. Patel. That approach continued right the way through to trial, up to trial, and at the trial itself. And of course, the claimant's well aware that this is the nature of the defendant's case. It's set out in the application. But subsequent to that, this wasn't a case where the defendants then wrote saying, we're not pursuing the fundamental dishonesty allegations any further, which might have changed the approach that the claimants and their solicitors took to the litigation. They served witness evidence when the time for witness evidence exchange came, which included a statement from Mr. Ferguson setting out the allegation that the claimant, first claimant, and the witness knew each other. And they served another witness statement from Miss Kimpton, to which I've already made reference, attaching various photographs from the claimant's Instagram and Facebook pages. I confess, having looked at that evidence, and it is in the trial bundle, the supplemental bundle, in case the court wished to see it, it doesn't seem to me that there was anything that supported the defendant's case at all, and indeed that's the conclusion.
That's what I was just about to say to you. Having just sort of flicked through it, it seems that she did all these researches but got nowhere as a result.
Yes, and despite all of that, the defendants maintained their approach right the way through the trial preparation period, up to trial and at the trial. Excuse me. And the fact that nothing had changed is made clear by Her Honour Judge Backhouse in the judgment on the application for indemnity costs, which is in the core bundle.
Yes.
At page 109. I no doubt, my ladies and my lord, have read this short judgment, so I don't propose to go through it line by line. Paragraphs 2 and 3 are the crucial conclusions. But paragraph 2, the judge expressly says that she harks back to the judgment on the CCNC, the application hearing, and says that she had her doubts as to whether this was a proper case for raising and pursuing this allegation. She concludes that there was nothing beyond the fact that the three claimants were saying the same thing and the hearsay evidence of the investigator. And she says in the penultimate paragraph, certainly this case had none of the hallmarks of the sort of fundamentally dishonest claims that this court sees all too frequently. I do wonder whether Parliament intended that blunt tool, by which I infer she means section 57, to be used for cases like this. In paragraph 3, she perhaps bemoans what might have happened before defendants were encouraged in this way by section 57. But then importantly says that insurers have to investigate cases, but it would be very sad if public-spirited people were deterred from coming forward as witnesses because of the potential allegations of fraud.
Mr. Latham, can you just remind me, and I should know, but if I did, I've forgotten. Fundamental dishonesty is obviously introduced by Section 57 of the 2015 Act.
Yes.
But Rule 44, I think it's 15, either 15 or 16, refers to fundamental dishonesty. Did that predate the Act?
It did.
I thought
that
so.
was in 2013.
Yeah.
44.
So fundamental dishonesty was always a way out of quocks long before the legislation and used those words, fundamentally dishonest.
Yes, it did.
Yeah.
The what the Act, the 2015 Act, added was two things. Firstly, that where a claim had a genuine element but had been exaggerated by fundamental dishonesty, that the court could disallow the entire claim. So
Yes.
if there was a genuine claim worth £250,000, but
Yeah.
the claimant...
But for our purposes, focusing on can you get out of quocks, that the Act didn't make any difference because the rule was always there.
Yes. For the purposes of getting out of quocks, then yes, that's right.
Yeah.
And that's 44, 15 or 16?
I think it's 15.
Thank
It's
you,
the scope of quocks.
So well done, the CPRC.
Yes.
It was only a matter of time.
It's 16. My lady's right. It's 44:16. Orders for costs made against the claimant may be enforced to the full extent of such orders with the permission of the court where the claim is found on the balance of probabilities to be fundamentally dishonest.
Right, have we done enough on the facts? Is that the material you want to take us to before addressing any points of law or your submissions as such?
Yes.
Well then, before we leave the facts, can I just ask you this? Was Mr. Mican accused of lying? Was he in cross-examination?
He wasn't. It wasn't
Was
clear to
not.
him that he was lying.
And it may be just, obviously, not at the heart of this appeal, but Mr. Khan's correspondence pre-action has caught my eye.
Yes.
You've read it.
Yes.
So the first response he makes at page 167 of the supplementary bundle to insurers saying, we haven't actually been notified of this accident. Mr. Khan responds by describing the defendant's driving as reckless, being in a hurry to flee the accident scene and attacking his credibility. The next letter at 169, your client's credibility is seriously flawed. References in the 4th, 5th paragraph to fabricating the truth and perverting justice. Is there anything you would like to say about that sort of correspondence, given the line of authorities, which makes it very clear how the parties are supposed to conduct themselves in correspondence of this nature?
Yes, those two emails are responses to the defendant's contentions that the three claimants are not...
No, it's not. No, they're not. No. The first letter, 169,
Yes.
is simply responding to 167. Forgive me. Is simply responding to insurers saying this is the first we've heard of it. 166. 168 is simply saying that liability is in dispute and asking for documents. So fraud isn't on the agenda at all at that stage. Anyway, take a moment, don't answer it now, but it
Thank
does
you.
look to me as if your clients were, solicitors at least, were pretty ready to allege dishonesty first, actually. Have a think about that and come back to me. It's not obviously...
I'll make a note. And come back
just
to
I want to, in fairness, give you the opportunity to comment on that.
Thank you.
At a moment convenient to you. But I think now to your main submissions. I mean, speaking for myself, I found that all very helpful to go through some of the facts. So if there is anything else on the facts that you would like to highlight, please do that.
Thank you, milady. I'll check my notes to make sure I haven't missed anything.
Good. Right.
Thank you, my lady. No, there's nothing else on the facts I'd like to address you.
Thank you.
Returning to the appeal itself,
Yes.
it effectively comes in two prongs. The first is that the judge misdirected herself or was misdirected, however inadvertently, as to the correct test. And I say that she either applied the wrong test or in any event, failed to give reasons for the conclusion that she reached. So far as the correct test is concerned, first of all, my learned friend and I agreed on the law, which stems from Excelsior. It's set out. Would it be preferable for me to take the court to my skeleton argument,
Yes.
which quotes it?
Yes.
Page. Forgive me. Do you have it separately from the bundles, or would it be more?
Bundle page for me, please.
Yeah.
Both, I'm afraid.
Okay. Well, it's internal page 8. Which is page 23 of the court.
Yes.
Now, I've described, perhaps rather optimistically, paragraph 13, the law is well-trodden ground, and in part that's true, but for reasons which will become clear in a moment, it's perhaps less true as to how allegations of fraud and dishonesty interact. But certainly the first few subparagraphs. Paragraph A is the CPR rule itself that the court has to regard, take into account all of the circumstances, including whether it was reasonable to raise a particular allegation or issue and the manner in which those allegations or issues are raised. Paragraph little b, I cite a short sentence from Excalibur Ventures, which simply says that Part 44 makes clear that the conduct of the parties is one, but only one, of the circumstances to be taken into account, and that discretion has to be exercised in light of all of the circumstances of the case. And then at little c, at the top of the next page, from the Court of Appeals decision in Excelsior Commercial, and I think really this encapsulates the test. The question will always be, is there something in the conduct of the action, all the circumstances of the case, which takes the case out of the norm in a way which justifies orders for indemnity costs? Now, if I may take the court to the core bundle at page 112, we can see the submissions that were made to the judge in advance of her decision. And they are brief, and the defendant, respondent, makes much of that in their skeleton argument. But at page 112, Mr. Buchan makes the application,
Yes.
and then Mr. Sharp responds, and his opening line is, for such an award to be made, it has to be something exceptional in these sort of cases. It might simply have been in these sorts of cases. He then develops a submission that there is perfectly proper to put the application, he says, that the application was refused, and concludes 4 lines down, there is nothing sufficiently exceptional about this.
Yep.
When it comes to the judge's decision, which is back a few pages on page 109, the judge doesn't set out the test that she is applying. On any view, in my respectful submission, Mr. Sharp's submission was incorrect. The test is not one of exceptionality. It is whether or not the facts and circumstances of the case or the party's conduct are out of the norm, as we see from Excelsior. What the judge says at paragraph 3, 3 lines up from the bottom of paragraph 3, having set out in my submission, and I'll come back to this in a moment, but having set out a number of factors which point towards making an indemnity costs award, and having observed nothing which would point against making such an award, she simply says, but I cannot say that the conduct of the defendants meets the test for indemnity costs. If I may, I'll respond to a point that the respondents make in their skeleton argument on this appeal by reference to the case of Whaley's Bradford, which perhaps rather neatly deals with this question.
Sorry, responding to which point?
To this point about whether or not the correct test was applied.
All right.
If I may take the court to the authorities bundle,
Yes.
page 194. This is Lord Justice Newey's decision. Paragraph 21. In fact, if I can perhaps pause there rather than read that out and invite the bench to refresh memories of what's said in paragraph 21.
What's your point? Why do we need this case?
Forgive me, the point is this. In Whaley's, the judge in giving judgment had said, I don't think this case amounts to exceptional circumstances.
Yes.
And the conclusion of the Court of Appeal.
It's not going to help us, is it? I mean, it's a fact-specific case.
Well, it's fact-specific in the sense that what the court says at the bottom of page 194 is that in the particular circumstances of the case, the use of the word exceptional might be consistent with the judge having applied the correct principles of
Right.
out of the norm.
Yes.
The reason for that conclusion, though, and that's the point that the respondent prays in 8.
Right.
The reason for that conclusion is foreshadowed in the first few lines of paragraph 21, when it's made clear that Mr. Gale, counsel for Whaley's, had submitted to the first instance judge that there were circumstances taking the case out of the norm, such that indemnity costs should be applied. So the distinction between the approach in Whaley's or Wally's is that in that case, the judge had been told the correct test in the course of submissions
Right.
and had slipped into using
Fine. Okay.
the term exceptional circumstances. In this case, it's obviously different. If I move forward very briefly to page 196, 2 pages forward, Lord Justice David Richards, paragraph 28, offered some broader guidance that the court should be careful with their linguistics and should make sure that they don't slip into using terms such as exceptional when the test is not one of exceptionality, but one of whether the circumstances or the conduct are out of the norm. In my respectful submission, what's clear, looking at the submissions that were made to Judge Backhouse and the single line of her judgment which makes reference to the test, is that she was likely applying the wrong test.
But here's a highly experienced judge, presumably doing these types of cases on a regular basis, frequent basis, and frequently dealing with applications for indemnity costs. What's the answer to that? I mean, your point still stands good. I'm just putting it to you.
Well, we have all momentarily, I'm sure, forgotten the precise details of a test, a legal test, if it's not one we've been reminded of in the relatively recent past. I know nothing of Her Honour Judge Backhouse's experience and the frequency with which she deals with applications of this kind. But what I would say is if she did know that the test was not exceptionality, but rather out of the norm, I might have expected her to say, well, Mr. Sharp, that's not the test, is it? She didn't do that. And she didn't make clear in her judgment, as she might have done if she didn't challenge the advocate, the test is whether or not the circumstances are out of the norm. In my view, this is not a case that is out of the norm for these reasons, and she doesn't do any of that. So in my submission, the fact that she doesn't challenge the test that's put to her is an indication that she simply accepted the submission. My second point, going back to the Judge Backhouse's judgment, which is page 109 of the core bundle, is that she inappropriately restricts her consideration to the conduct of the defendant. So again, it's that same sentence at the bottom of paragraph 3. I cannot say that the conduct of the defendants meets the test for indemnity costs. Of course, as I've just taken this court to in Excalibur Ventures, the Court of Appeal, this court said that Part 44 made it clear that conduct is only one of the factors that the court ought to take into account. And it's right to say that extempore judgments can often be said to have been put in ways which might be better expressed had the judge had more time and perhaps prepared a written judgment, but that extempore judgments are nonetheless an important feature of civil litigation. But what's important here is that is the only element of the test that the judge turns her mind to.
What in the phrase conduct of the defendant was excluded, do you say, by the judge?
Well, it's difficult to say. What the judge does at paragraphs 2 and 3 is set out a number of features of the way, a number of features of the defendant's conduct. So she does take into account that she'd given a steer, for want of a better word, a year ago or so, that this was probably not a proper case for pursuing a claim.
Isn't that a circumstance?
Forgive me.
Is that not a circumstance? I mean, didn't she really... What did she not refer to, do you say?
Well, she failed to balance the nature of the claim itself and all of the factors of the case. She clearly focused her attention only on the conduct.
Well, so last opportunity, what factor, what material factor do you say she wrongly excluded from her consideration?
If you forgive me one moment.
Yes. Sorry to press, but... I thought she did apply the wrong things. I was persuaded, but I didn't see any point of principle in it. But I think she may have applied the wrong thing. Not a second appeal. If you look at the conduct... just see... Yeah, yeah. It's just gone. Yes. Yes, go on.
Thank you. One point might be that, for example, the nature of the claimant and the nature of the witness and the fact that the allegations have been hanging over them and the impact that that had on the claimants and the witness. One of the points that's made by Mr. Buchan in his short submissions on the point is that this had been hanging over the head of those individuals. And that's particularly relevant. I'll develop this in more detail in due course. But it's particularly relevant in this case because the first claimant was a principal accountant for the Royal Kensington and Chelsea Tenant Management Association or organisation. Had there been a finding of dishonesty against him, he almost certainly would have had to report that to his regulatory body as an accountant. And that may have had very serious professional consequences for him. It may also be something that he would be required to report to his employer in those circumstances.
Okay, all right.
The independent witness was similarly a director of a number of companies. Mm-hmm. And again, a finding of dishonesty against him may affect his ability to discharge those roles now or in the future. The final point, and it's a point that was actually made in the defendant's own correspondence in January 2020, is that had there been findings against them, they would undoubtedly have found it difficult to obtain insurance, car insurance or any other type of insurance in the future because their names would be entered onto the fraud register, the insurance fraud register. Now, I appreciate that those points I've now developed are all encapsulated in Mr. Buchan's submission, that this has been hanging over their heads. But of course, the judge had the context of this litigation by this stage. And so in my submission, that brief indicator ought to have been enough. When we look at the judgment on page 109, paragraph 2 essentially focuses exclusively on the conduct of the defendants in making allegations which couldn't be substantiated, that really ought not to have been made. That this was a case which had none of the hallmarks of fundamental dishonesty that one sees. That the insurers had acted in a way which was likely to, these are my words, not the judge's, but likely to interfere with the administration of justice, because it would likely put independent witnesses off offering their assistance in the future if these sorts of allegations would be made. Now, as well as in my submission inappropriately focusing her attention on just the conduct of the defendants as opposed to those wider circumstances that perhaps flowed from those allegations, all of the points that I've just made, that I draw from paragraphs 2 and 3 of the judge's judgment, point in favour of making an award of indemnity costs. Every single one of them is critical of the defendants. She also says in the antepenultimate sentence of paragraph 3 that the raising of fundamental dishonesty, she thinks, has caused quite clearly both parties to incur far more costs than were necessary. And she's right about that, and there's Court of Appeal authority to the effect that I'll turn to in a moment, but it's the case of Thakkar, where the Court of Appeals said, well, when these sorts of allegations are made against a claimant, they are undoubtedly going to leave no stone unturned in responding to them and will incur more costs.
Well, that's a matter of fact.
It is a matter of fact, and it's a fact that the
Court
judge...
of Appeals said in another case about leaving no stone unturned is on the facts of that case. I mean, that doesn't detract from your point that the judge here found
Yes.
that there were additional authorities, there were additional costs as a result of the dishonesty. That point's plainly open to you, but I'm not sure that what other judges said about the costs incurred in other cases apply.
Well, my lord,
That is one of the things that's a bit vague here is actually what the additional costs were. I don't think this is one of those cases where somebody's done an analysis of without those allegations the costs would have been 40,000, with those allegations the costs are 100,000.
No, certainly no such...
I mean, none of that detracts from your hanging over their head point. I completely get that. But just in terms of the increases in costs, that is all a bit vaguer.
My lord, yes. What I would say about the Thakkar authority, and perhaps it's useful to turn that up now whilst I'm addressing it. It's in the authorities bundle, page 159.
159?
159.
Thank you.
Paragraph 18 is that, this is Lord Justice Briggs, he isn't addressing, in paragraph 18, it seems to me, the facts of that particular case.
No, he's addressing crash for cash,
Well, yes,
as it was known,
yes.
and which, of course, this case isn't.
No, but more broadly, he's addressing the circumstances where a defendant insurer alleges that their claim is dishonestly brought and there's a conspiracy to fraud. And those are precisely the allegations we put in this case. Not that the accident had been contrived, but a different type of conspiracy to defraud involving 4 gentlemen who, on the defendant's pleaded case, had been sat in a moving car with the engine on and had driven into the defendant's vehicle, as opposed to their own case where they were sat in a car with the engine off that was stationary. And that what happened after the accident was the conspiracy, as opposed to the accident itself being the product of a conspiracy to defraud. And in my respectful submission, paragraph 18 is of wider application. I take my Lord's point that what was said in another case might be a relatively limited application on this case, and perhaps I don't need to push this point too hard because, as a matter of fact, the judge in this case found that costs had been incurred over and above that which they would have done. There's no respondent's notice to challenge that conclusion. So I hope you'll forgive me if I'm pushing the point inappropriately, but paragraph 18 is a conversation in the round that in cases where those allegations are made, as opposed to in CADA itself, where there is an allegation of a sophisticated conspiracy to defraud, where the consequences for a claimant being found to have been party to the fraudulent contriving of a road traffic accident may...
I mean, this is the context, see paragraph 16 of a discussion about claims coming out of the protocol.
Yes.
And going under part 7.
Yes, in CADA, it addressed the what was described, I think, colloquially at the time as a lacuna in the rules.
Yep.
That cases which had been allocated to the multi-track would still attract fixed costs if they were started on the RTA portal. And CADA said that wasn't the intention, and subsequently the Rules Committee updated the rules to make clear that where a case is allocated to the multi-track, fixed costs no longer applied. So my lady is entirely right that that's the context of this appeal, but the point stands that where these allegations are made, all claimants, whether you're a chartered accountant, a solicitor, a barrister, a doctor, perhaps somebody where there would likely be no professional consequences, everybody is entitled to defend those claims. But where the potential consequences of a finding of dishonesty could be the end of your career, that is significant. And you would rightly instruct your solicitors to investigate this in a far more detailed way and spend far more in costs than would otherwise be the case.
Right, I think we've got that point. So,
Excuse me.
misdirection is the correct test. Applied the wrong test.
Yes.
And where you at? Yes.
And then reached a conclusion in my submission that no judge...
They reached a perverse conclusion.
Reached a perverse conclusion.
So outside the ambit that appellate interference is justified.
Exactly that. And I recognise immediately that the need for appellate restraint in matters such as that is well versed in the authorities, and my learned friend sets some out in his skeleton argument. Mm-hmm. What I would say, one of the points that, before I perhaps move on to the second prong, is this idea that the judge failed to give reasons. Mm-hmm. And the reason for that is, I hope set out clearly in the skeleton argument, but you'll see from paragraphs 2 and 3 of the judgment that we've just looked at on page 109 of the core bundle, that every single sentence in my submission points towards the making of an indemnity costs award. Every sentence, every aspect of the case that the judge takes into account is critical of the defendant's conduct or points to this being a case where such an order is appropriate. In that context, the sentence, I cannot say the conduct of the defendant meets the test, in my respectful submission, is entirely inconsistent with what goes before it. There is no explanation as to why, in spite of all of those factors, the test is not met. One might expect to see a judge say, I take all of those points into account, but ultimately the one point that I find the most compelling is this, and that points against. Or all of those points point towards, but here are a few points that point against, and weighing those factors in the balance, my view is that the test is not met. With greatest respect to the judge, she doesn't do any of that. She takes effectively all of the points in favour and then, without explaining why, concludes that the test is not met. I don't propose to take you through, take my ladies, my lord, through the various paragraphs of English and Emery, unless it would assist. Yep. I suspect that those are principles that this court's well familiar with. But Mrs. Justice Bacon perhaps succinctly identified the shortcomings of the trial judge when she granted permission on the first appeal. That's at page 268 of the core bundle.
really going to be helped by this, are we?
Perhaps not. Perhaps I can simply say that the three failures that Mrs. Justice Bacon identifies I adopt and say that she was right to have concerns over the lack of explanation as to why, having made the comments she did, she concluded that this wasn't a case that was out of the norm. The answer to that might be that she was applying too high a test in applying a test of exceptionality, which ties into my first point. Essentially, English and Emery, if I was to try and distill those various paragraphs down into a sentence, says this: a court should always give reasons for its decision. Where it fails to do so, unless it is absolutely obvious from the context why the court ordered as it did, then the appeal should be allowed. And in my submission, this isn't one of those cases where you can say, okay, well, the judge didn't give reasons, but it's entirely clear from everything else she said why she declined the application for indemnity costs. In my submission, the contrary is true.
So this submission is essentially, if you look at paragraphs 2 and 3, you say the penultimate sentence comes as a surprise.
It does, yes.
It's like the old forensic fable where the word not was added.
Yes, exactly.
Right.
If you're with me on that, and we turn to the question of what this court does, in my submission, this court ought to exercise its discretion afresh. And I'll deal in a moment with the reasons why I say that the indemnity costs award ought to have been allowed. If you're against me on that question, what I'll call the English and Emery question, then I still say that the judge reached a conclusion, the perverse conclusion, point my lady, the Lord Chief Justice has just made, that she acted outside of the exercise of her discretion in any event. Now, the court will have seen from the skeletons and the authorities bundle that both parties have referred to a number of High Court decisions which address how failed allegations of fraud ought to interact with applications for indemnity costs. I'll take the court through those in a moment, but just before I turn to those High Court authorities, may I invite your ladyships and your lordship to consider this court's decision in Carcou, which is in the authorities bundle at page 100.
And how are we doing for time?
Where
are you going? Can you just give us a route map now?
Yes, I'm going to, or I propose to, take you through. There are 6 authorities that the parties refer to, High Court authorities.
Right.
4 of which point in favour of the submission I make, which is that where failed allegations of fraud are made, the starting point should be an award of indemnity costs. 2 are referred to in addition by the respondents. I'll say that one of those is neutral on the point, and one does go against me, but also against the thrust of the other 4.
Okay.
And then invite you to consider what the correct approach is and perhaps give
Right,
guidance.
well, you can go through these authorities pretty quickly.
Yes, I
Yes. So that's that. And then anything else?
will. No, that really would conclude my submission. I'll explain why I say that the correct approach and what the guidance that this court should give is that where allegations like this are made, the starting point should be the indemnity basis. And I'll conclude by saying, even if I'm wrong about that, and that the starting point is the standard basis, that the facts of this case were such that the judge ought to have awarded indemnity costs.
Okay. Good. Well, I think that all sounds sensible, but perhaps aim for around noon. See how we go. But I think you can take these first instance decisions fairly quickly.
Okay, I will do that.
Is that okay? Is that okay? Yeah. Right.
Well,
Authorities
I'll
bundle.
deal extremely quickly with the point on Carcou, which page 100 of the authorities bundle.
100.
100. It's perhaps a point that's trite, but as the Court of Appeal, this court has said it already. It perhaps has more weight coming in the form of this authority than from my humble submissions. Paragraph 27,
Yes.
right in the middle of page 100, about halfway down the 10th line, the line begins by making an order for indemnity costs. Excuse me. And this court said that
That was in circumstances of a dishonest claim.
a dishonest claim, that's right. So different to this case, the claim was found to be dishonest as opposed to an allegation of dishonesty failing.
Yep.
The court recognised that there were two reasons why in those circumstances it was appropriate to award indemnity costs. There's two reasons were that, first of all, the innocent party was likely to have to incur extra costs in responding to the claim or I'll say the allegations. And secondly, because it was important in the interests of justice that others should be discouraged from bringing dishonest claims. And drawing those 2 points to the facts of this case, I say, well, first of all, you have the finding of fact by the judge that more costs were incurred, and that's supported loosely by the principles espoused in CADA. But also that it would be important, and it is important in my submission, that defendants who don't have a reasonable basis for pleading fraud or fundamental dishonesty ought to be discouraged from doing so.
Yes.
And
Right, so that's the point made there.
that's the point made there.
Yeah.
The first instance decisions, first of all, page 77 of the bundle. This is the Three Rivers case.
Yes.
At the bottom of page 77, considering the circumstances in which an indemnity costs award should be made, Mr. Justice Tomlinson, as he was at the time, subparagraph 5 deals with speculative, weak, opportunistic or thin cases, which I say this was, and the judge made findings to that effect. The weakness of the fundamental dishonesty claim or allegation. Paragraph 6, where the claim includes allegations of dishonesty, let alone allegations of conduct relating an award to the claimant of exemplary damages, and those allegations are pursued aggressively, inter alia by hostile cross-examination, and again drawing the facts back to this
This
case.
isn't setting out a principle, is it? This is just saying following principles should guide the court's determination.
Yes.
There's just a series of factors that may or may not be relevant, depending on the facts. Is it
But-
setting out a default rule or a starting point?
Subparagraph 8 it perhaps goes the closest to doing that when it says the following circumstances take a case out of the norm and justify an order for indemnity costs. And that's when A and B, when the claimant advances and aggressively pursues serious, wide-ranging allegations of dishonesty and impropriety over an extended period of time. And here we know it was from the investigators attended in 2017, perhaps pursued more vigorously post the application. Then at B, where the claimant advances and aggressively pursues such allegations despite the lack of any foundation in the documentary evidence for those allegations and maintains the allegations without apology to the bitter end. Again, precisely the circumstances we have here and found by Judge Backhouse. No documentary support for that at all. So in my submission, subparagraph 8 does seek to lay down that point of principle. Going slightly back in the bundle, page 51,
Yes.
you have the decision of Mr. Justice Christopher Clark, as he was at the time in Balmoral Group. Forgive me, my lady will see paragraph 1. He takes into account the Three Rivers case that we've just looked at, and he summarises it. And then in the line, about halfway down paragraph 1, which says the norm, he says there must therefore be something, whether it's the conduct of the claimant or the circumstances of the case, which take the case outside the norm, that's the Excelsior and Excalibur tests. Not necessarily the claimant should be guilty of dishonesty or moral blame. Unreasonableness in the conduct of the proceedings and the raising of particular allegations or the manner in raising them may suffice. So may the pursuit of a speculative claim involving a high risk of failure or the making of allegations of dishonesty that turn out to be misconceived. In my submission, that's consistent with the approach in Three Rivers. But perhaps the clearest statements of a principle are in Clutterbrook and Metaxas. So Clutterbrook's on page 149.
Sorry, give me the page reference.
149, my lord.
Yeah, I think so.
Paragraph 16, in the middle of the page. Mr. Ilias, on behalf of the claimant, submits that an allegation of fraud being made in the proceedings, which then is discontinued, the facts of that case, the claim was discontinued after the allegation had been made, is not itself a reason to order indemnity costs. The general provision in relation to cases in which allegations of fraud are made is that if they proceed to trial and the case fails, then in the ordinary course of events, the claimants will be ordered to pay the costs on an indemnity basis.
This is Mr. Ilias's submission, so where is that accepted?
Paragraph 17 explains the rationale that the seriousness of the allegations of fraud where they fail should be marked with an order for indemnity costs. Then at paragraph 19, the defendant has been put in this case to considerable expense in defending to date the allegations made. As I mentioned earlier, so it seems to me clear that these are the words of the judge rather than the submissions of Mr. Ilias.
What you're looking for is paragraph 20.
And then
I
I'm
therefore
very
consider
grateful,
that
my lady.
allegations of fraud will in general justify the court in ordering costs upon the indemnity
Yes.
basis.
And that is a clear statement of principle. I appreciate it's not one that binds this court, but it's consistent with the two authorities I've taken you to already. And then post-dating Clutterbrook is Metaxas, which is on page 214.
I'm not undermining what you say, but I think it's important that everybody's accurate. It's about justifying the court in ordering costs on an indemnity basis where the claimant serves notice of discontinuance.
Yes, they're the facts of this case. So the claimant had alleged fraud,
Yep.
put the defendant to expense, and then discontinued. In my submission, it's even more a case of indemnity costs being justified where the party that alleges fraud doesn't concede that point at any stage, but rather
Understood.
puts the claimants to
Understood.
hostile cross-examination.
Yes.
And then that principle is developed slightly further by Mr. Justice Bryan in the Taxis, page 211, forgive me, of the bundle, 211. Starting at paragraph 49, the principle in Clutterbrook is in fact accepted by the parties. It's accepted by Mr. Weeks that because of cases such as Clutterbrook, the starting point at least is if you make a fraud claim and pursue it, then either withdraw it or lose it at trial. The starting point is an order for indemnity costs. Nevertheless, he rightly points out, as I foreshadowed, that the court retains a complete discretion, and I accept that entirely. And that's important for a point I'll come back to in a moment. So this is a shifting of the starting point, not an automatic consequence. I don't say, and I make this clear if it isn't already, that as soon as an allegation is made, automatically it's indemnity costs. I don't say that. What I say is it shifts the starting point.
What does that mean?
Well, excuse me, I say it means what Mr. Justice Bryan says in paragraph 49. The starting point then is indemnity costs, and if there are reasons why indemnity costs award would be inappropriate, then the court retains that discretion to say, well, for this reason, that reason.
I mean, in the field of costs, is it helpful at all to talk about a starting point in this context? Isn't the starting point the court has complete discretion?
There is a complete
And
discretion.
factors that may be relevant in exercising it are whether or not you've pursued a case in fraud that's failed. But
that-
starting points, sorry, there we are. What do you say to that?
Well, my submission really is answered by what Mr. Justice Bryan goes on to say in this case, but I'll try and summarise it in a sentence or two. It's that there is good reason, because of the consequences of making these allegations, which I'll come on to in a moment, there is a good reason why the starting point should be something other than standard basis costs. And whilst the court will retain that discretion, the nature of the allegation and the fact that a party incurs more costs, costs which in a standard basis assessment are unlikely to be recovered. I make the point in my skeleton argument that
just before you get into the detail,
Yes.
I'm still trying to work out, do you say that the starting point switches the burden? Because as my lady has said, the starting point is the court retains complete discretion. So if you've got dishonesty allegations which have failed, do you say that that then means that you take as your starting point that the fact that indemnity costs will be due unless reasons can be shown to the contrary?
I do say that that would be the appropriate guidance.
And therefore you're saying that actually it is a complete discretion in the judge, but in circumstances like these, one starts with the dial at the top.
Yes.
And the discretion, as my lord has said, and I'm sorry to have interrupted both you and him, is that nevertheless, despite that it is a complete discretion, one's dial starts here, and then exercising one's discretion, one has to take into account factors which move you away from that point.
Yes.
So actually, you would say it's a complete discretion, but it does have a starting point, I assume.
My lady puts it far clearer than I have thus far, but that is exactly the point that I make. One of the authorities that my learned friend prays in aid expressly says, well, the starting point in all costs is the standard basis, and draws on the rule at 44.2 to say that costs are either on the standard or the indemnity basis, and if the court doesn't state the basis or says anything else, then it's the standard basis. So it's really correcting that, the lens, if you like, through which the balance of the submissions ought to be viewed. And if I may take you ladies, my lord, to paragraph 50 of Mr. Justice Bryant's decision, these are effectively, I appreciate this isn't binding, but these are effectively the reasons why I say that is the appropriate starting point. Paragraph 50 deals with the submissions being made by the party that alleged fraud, Marix. Third line, that's counsel for Marix, says that Marix's decision to bring the fraud claim was not unreasonable, let alone unreasonable to a high degree, and certainly not...
Why do we need the facts of Marix? What's the point of principle that you want from this?
Well, paragraph 53 is perhaps the clearest statement. Page 212. Mr. Justice Bryant says, I consider that the starting point is indeed that costs should be on an indemnity basis. He then turns to the various facts in that case which might point against. He says at paragraph 56 that there were features of this case which were comparable to the Three Rivers case, and those are, I can take you to them if it would be helpful, but effectively those are the fact that it was run to trial, the fact that there was hostile cross-examination, etc. Interestingly, and similarly to this case, the second part of paragraph 56, Mr. Justice Bryant says, I consider it's questionable whether it was appropriate to plead fraud in the first place.
Yeah, I'm not myself finding comparisons with like for like particularly helpful. Is it 53 you want? 49 and 53 are your key points here, are they?
Yes.
Thank you.
I would perhaps just add that paragraph 56 and 58 take into account the fact that where the allegation is not corroborated or substantiated beyond suspicion, then that is another factor that points in favour. And in fact, paragraph 59 makes the same point. The two cases that my learned friend relies on in response are Bishopsgate and Libyan Investments. Bishopsgate is at page 239.
These are the two most recent.
The two most recent, that's right.
Which consider all of the authorities you've
been
through.
And that's why it's important for me to address what's said in those two cases. So page 239, paragraph 16, subparagraph 4.
And who is this?
This is Mr. Justice Linden.
Thank you.
In expressly considering the position or the judgments in Clutterbrook, it says, in relation to this authority, Mr. Forshaw, one of the advocates, came close to submitting that as a matter of course, if an allegation of fraud or dishonesty have failed, the costs must be ordered to be assessed on the indemnity basis. And that's why I was at pains to say that that's not my position
Yes.
on this appeal.
Okay, we've got that.
And goes on to say, there is, in my view, no such rule in the context of applications. I accept that. And as I have said, where such allegations are made and fail, that may be a reason for making such orders. It stops, in my submission, that's right. And that's why I described it in my earlier submission as neutral. All that that case says is that there isn't an automatic entitlement to indemnity costs simply because of the government, which I accept.
And so the other authority
The other one,
is-
page 267, Libyan Investment. In my respect for submission, Mr. Justice Miles perhaps slightly misinterprets the conclusions in Bishop. Because forgive me, page 267
Yes.
starts with a quote from Bishopsgate, the paragraph 16 to which I've just referred. And then the analysis comes in paragraph 9 at the top of page 268.
Thank you.
The judge says two things. First of all, that would be a factor to take into account in dealing with the basis of assessment, but there's no automatic rule, which means that where those allegations fail at trial, costs.
I think the or
on the
is
indemnity basis.
strayed in. I think it makes perfect sense if you just delete the or, don't you think? On the basis of assessment, but there is no automatic rule.
Yes, I think you're, my lord's entirely right. The word "or" should come out. So the two things that he concludes in paragraph 9 are, firstly, there's no automatic rule that that allegation equals indemnity costs if it fails, and I accept that. And I also say that's a correct categorisation of the conclusions in Bishopgate. But then he goes on to say, or even operate as a starting point in the sense that the paying party is then required to explain. Now, none of the authorities that he reviews in the preceding paragraphs expressly say or even imply that there shouldn't be the starting point. In fact, to the contrary, Clutterbrook and, in my submission of taxes, both say that that should be the starting point.
Yeah, but he says operate as a starting point in the sense that it goes back to the points the court's been making.
Yes.
Is there then sort of some shifting of an evidential burden or some other burden demanding an explanation? I mean, a starting point can be simply an open starting point where both parties are on an equal footing to argue it either way. So is the qualification not important? Is there anything in any of the authorities you've taken us to suggest there is a starting point in the sense that the paying party is then required to explain why indemnity costs are not appropriate? So is there any authority in the ones you've taken us to which says, and therefore, the paying party is required to explain why indemnity costs are not appropriate?
Well, in my submission, that's what the taxes does.
Right.
So paragraph 53, page 212 of the
Yes.
authorities bundle, the judge says that in those circumstances, he considers the starting point to be indemnity basis.
Yes, but
He then goes on in paragraph 54 to look at the submission that was made to him that it was inappropriate to order those costs on an indemnity basis because it was reasonable for the defendants to take the point. And he ultimately concludes that
So,
it wasn't
so you agree he doesn't say it, but you say you can infer that out of paragraphs 54 onwards.
Yes, 54 to 59 is the judge then looking at. He doesn't, for example, say, paragraph 53, starting point is indemnity basis, therefore costs are on the indemnity basis. He then goes on at paragraph 54 to look at the submissions that were put to him about whether or not it was reasonable to take the point or whether or not the point was supported with corroborative evidence, so on and so forth.
So you say, as I said, as I put to you, can I repeat it? You agree he doesn't say this changes the burden or requires them to say why it's not appropriate, but you say you can infer that from paragraphs 54 onwards.
I do.
am I wrong to wonder whether or not we're just massively overcomplicating?
I can see why my lady might take that
It's,
view.
it's clearly a highly material factor. Why do we need starting points?
Well, it may be that you don't. I say that that would certainly be helpful guidance in the context of civil litigation at the moment, where we have the points being made regularly, often, albeit appreciate the court doesn't have any evidence on this point, but this case is perhaps a prime example of a circumstance where a defendant insurer has taken right the way to a trial a bad fraud point, which is wholly uncorroborated. And they are, as I hope it wasn't too grand of me to draw the 3 paragraphs I did at the beginning of my skeleton to try and set the scene. This is in the context of the Act, the 2015 Act. There is no penalty if this judge was right to do what she did. There is no penalty and no potential risk for a defendant to make an allegation of fundamental dishonesty. It seems to me, where there is a genuine claim and the allegation is raised, there are 3 possible outcomes. The first is that the claim settles at an undervalue because the claimant accepts a low ball offer because they don't want to risk going to trial and having a finding made against them. It's 2 impacts. First of all, it's a windfall for the defendants, but secondly, it impedes the claimant's access to full justice. The second potential outcome is that the claimant discontinues. One doesn't have to think too hard to think if I had a £3,000 or £6,000 whiplash injury and found myself staring down a defendant alleging that I was being fundamentally dishonest, that finding would end my career. I would be very cautious and frankly a fool to push on for the sake of £3,000 or some other similar modest general damages claim and put my entire career at risk. And perhaps it's relevant here that the claimants were all in their early 20s. So in that circumstance, lots of claimants will be dissuaded from continuing and will give up their legitimate, genuine claims. Access to justice is affected and the defendants achieve a windfall. The third possible outcome for a genuine claim is what happened in this case. They go all the way to trial. They're put through 2 days of trial and cross-examination on the basis that this is a conspiracy, and they succeed.
Yeah.
And
So,
they're left with, forgive me, my lady,
Oh.
they're left with a cost recovery from the defendant's perspective, exactly what they would have had to pay if they didn't take the point, standard basis assessment of costs. But more than that, in the context of the 2013 Jackson reforms, where claimants are often required to pay a shortfall of costs recovered, so damages are diluted.
yes.
We have circumstances where damages could potentially be diluted by accepting low offers to try and avoid a trial in circumstances where the claim is genuine. But even on those cases where the claimants go to a trial, their damages are diluted further still because they're only recovering costs on a standard basis.
So all strong arguments for there being penalisation in indemnity costs on the right facts, but why are those strong arguments in favour of some sort of rigid starting point?
Well, I say that the danger is without that guidance from this court, we have exactly the situation that we have had here, where a judge considering the submission that this is the case, which is not out of the norm, and we've seen what the Court of Appeal said in Carew about seeing things frequently, and that doesn't mean it's not outside of the norm. There ought to be a clear indication, in my respectful submission from this court to defendants, that where you make unsubstantiated allegations of this nature, the court will impose a cost consequence, because it's the only consequence that can be visited upon a defendant in these circumstances. The claimants have won. They're only entitled to normal damages. I make the point in my skeleton argument that even an award on the indemnity basis of costs arguably doesn't go far enough, because it's not a full recovery of all the costs that were incurred.
No, understood.
There will still be a shortfall.
Right, very helpful, thank you. Enough from me. Have we finished both the cases, the recent cases?
Yes.
Good.
Thank you. My lady, if I may just take 2 or 3 minutes
Yes,
to
certainly.
finalise those submissions, and I apologise
By all
if I
means.
cover any old ground. I'll try not to as much as... I set out in my skeleton at paragraph 14 the principles surrounding indemnity costs. there are two authorities. Neither of them are in the authorities bundle because my learned friend accepts the principle, which is that an award on the indemnity basis is still only compensatory. There will still be, it's an enhanced level of recovery, but it isn't a full recovery of costs. And it merely alters the extent to which the claimant does recover costs, but the claimant doesn't make a profit, of course. It's particularly important in my submission where allegations of fraud and fundamental dishonesty are raised, that claimants do achieve that enhanced recovery of costs. As I say, on a practical level, post-2013 more than ever, claimants who succeed in defeating these allegations will be left with a shortfall because there will always be, on a standard basis assessment where proportionality is at the forefront of the assessing judge's mind, in low value litigation like this, there will be a downward pressure on the costs which have been incurred. I've made the points with regards to the individual circumstances of the first claimant and the independent witness in this case, and I do say that they are particularly good examples of the impact that these allegations can have on individual claimants. And we've talked about the fact that qualified one-way cost shifting is alleviated when finding of fundamental dishonesty is made. There's also the fact that genuine claimants might lose their entitlement to damages and, as I've said, be left with a significant personal liability for costs to the defendant that they may or may not be able to pay. Taking a step back and looking at this in the round, my submission is that if this court were to give the guidance I urged it should, it will have a chilling effect on the approach of defendants who have the power to make these potentially ruinous allegations where they don't have any evidence to support it. There may well be cases where on the papers or on the evidence before trial, a defendant is perfectly entitled to make the allegations that it does. But it turns out, after cross-examination, hearing live evidence at trial, that the court can't be satisfied that there is fraud or that the claim is fundamentally dishonest. That would be a circumstance in which the exercise of the court's discretion would permit the judge to say, well, this isn't an appropriate case for indemnity costs, even though the allegations have failed. But without the starting point, if I call it that, there is absolutely nothing to stop defendants, large defendant insurers, making in RTA claims these allegations which hang over claimants' or litigants' heads for years until trial, if they have the mettle to keep it up, or even independent witnesses who've got no skin in the game. In short, it raises the stakes of the litigation in an unfair way because the risks that the defendants face are nowhere near matched by the risks that the claimants face when those submissions are, when those allegations are made. It threatens their liberty, it threatens their reputations, it threatens potentially their livelihoods. And whilst I accept that each case has to be dealt with on its facts, I do say that this court giving that guidance would be of great assistance to the profession. The final point, I'll make it in a sentence or two, is that even if I'm wrong about all of that, and if your ladies and my lord take the view that it's inappropriate to set a different starting point or to set a starting point, then on the facts of this case, for all of the reasons I've already drawn the court's attention to, it was entirely appropriate to award indemnity costs. And the judge fell into error and outside the generous ambit of her discretion in refusing the application.
And we should exercise that discretion afresh in the light of the matters you've drawn to our attention.
Indeed.
Thank you.
If I may turn my back a moment.
Any questions, Sarah? No. Have you got any questions, Peter? No.
Unless I can assist any further.
No, we are very grateful to you for your very clear, excellent submissions. Thank you very much indeed.
Thank you.
Yes, Mr. Mallory.
Ladies, my lord, thank you. My lady, I fully anticipate that in light of the very helpful submissions of Mr. Latham, that the court may have particular issues it would like me to address, which may well be out of the order in which I was otherwise intending to address them. Of course, the court will, and please do at any stage, direct me to any particular points you want me to address at
Yes,
any
of course.
stage.
Thank you.
May I just open briefly with a summary of our response to this appeal? There are really 3 points that we advance. The first is that dealing with the question of the specific decision made by this judge, we say properly considered, there is no proper basis on which this court can conclude that she applied the wrong test, that she erred in principle. And I'll come to this in a little more detail as necessary. But in short, we say firstly that a reference, and of course the reference was only by counsel for the defendant, it was not by the judge herself, but a reference to the question of whether a particular case is exceptional may, depending on the issue before the court, be entirely consistent with a consideration of whether the case is sufficiently out of the norm to justify indemnity basis costs. And this is precisely such a case, because really the only question the judge was being asked to address was whether this case was essentially a tall poppy, whether it stood out sufficiently from the usual run of road traffic accident cases before the court to justify an award of indemnity basis costs. And in that context, and I'm well aware that judges should avoid the use of the term exceptional in this circumstance, and of course this judge didn't actually use that term. In that context, even if she had used the term exceptional, there would be no reason for this court to conclude that she was doing anything other than applying the correct test. The second fundamental point we make is that assuming the judge did apply the correct test, there is no proper basis for saying that the judge then reached a decision that no reasonable judge properly directing herself could have reached on the facts in front of her. And of course it is trite that the issue is not the decision that this court may have arrived at on the same facts, but whether this judge went so far beyond the reasonable bounds of her discretion to fall into a clear error. In particular, again, in light of Mr. Latham's very helpful submissions, there were 2 key points that he said were relevant. I appreciate he in responses to questions from the bench, he sought to develop further points, but there were 2 key points that he persistently referred to as being relevant to why indemnity basis costs should have been ordered. And they were firstly that my client had persisted in saying that the claimants may have been dishonest. And secondly, that there was a risk that in so persisting, my clients may discourage witnesses from coming forward or giving evidence, and thereby inhibit access to justice. And whatever Mr. Latham endeavoured to develop in response to questions from the bench, it is absolutely clear, even in the very short judgment that the judge gives on this point, that she had both of those points, both of those key points, very firmly in mind. The third point we make, milady, is that it is not correct to say that authority, even authority below the level of this court, bound the judge to adopt a particular starting point in consideration of what award to make. Again, Mr. Latham has very helpfully and very carefully developed his client's submissions on this point. But in our respectful submission, we are here before this court on a second appeal, not a first appeal, a second appeal, because there is said to be an important point of principle. And as far as we are able to identify, that important point of principle is that very point. It is the attempt by the claimants here to establish what they describe in their grounds of appeal as a presumption that in certain circumstances indemnity basis costs should apply. I'm going to try and avoid trawling the court back through the various High Court decisions. But we say, firstly, it's not a correct analysis of those decisions to say that they provide for such a presumption. Secondly, even if they did, we would invite this court to say that that is not the proper basis on which the court should approach these matters. And thirdly, that there is, speaking to the wider public policy points that Mr. Latham has endeavoured to develop, there is no reason why, even if it was otherwise thought to be the case, why such a presumption should apply. Our case is that there are ample tools in the armoury of a trial judge, in the situation of the trial judge here, to indicate their displeasure, should they wish to do so, with the approach of any party in front of them, and ample tools to deal with the question of any additional remedy that that party might need by way of costs to address any particular trouble that that party considers they have been put to. So those are our 3 points. Before I endeavour to develop the first, which will address primarily the question of whether the judge erred in the test that she was applying, may I just, unless the court wishes me to go in a different direction, briefly develop the point about the question of costs, because this appeal is all about costs, and as my Lord Justice Coulson mentioned in an exchange with Mr. Latham, one of the oddities, of course, of this appeal, if we look at it as an individual appeal rather than a point of principle, is we don't actually know what we're talking about here in terms of figures. What we know is that the claimants have succeeded on their case. They have an order for costs. The judge has accepted, and I wouldn't demur from this, that by virtue of the allegation of dishonesty having been raised, the claimants will probably have spent more costs than they would have had that allegation not been raised. But the 2 things that we don't know are how much more, and perhaps more pertinently, what element of any extra it is that the claimants are concerned they might only recover with an indemnity basis costs order as opposed to a standard basis costs order. And the reason I mention this is because part of Mr. Latham's submissions was that absent this court adopting his approach of applying a presumption, pour encourager les autres, there was no consequence, in effect, for the defendants in having pursued this line. And we say that is fundamentally wrong. And if I can just briefly run through the cost consequences. The first is that this claim was taken out of fixed recoverable costs. It was a portal claim to start with. It came out of fixed recoverable costs because of a denial of liability. The second point is that any case that comes out of the portal on that basis remains a fixed recoverable costs case unless and until it is allocated to the multi-track. Now, the judge, the trial judge here, as this court knows, was also the judge who dealt with the Costs and Case Management Conference. At that Costs and Case Management Conference, after she had dealt with the question of the application to amend the claim, she came to the question of allocation to track. And if I can just, I'm only going to dip into the supplemental bundle very briefly, but if I could just invite the court to turn up page 29 of that supplemental bundle. Page 29. So this is the transcript of the Costs and Case Management Conference, which occurred on the 16th of July 2021. And so this is after the judge has dismissed the application. And at letter E, the parties came to the point about allocation. And in an exercise of what I will, in the best possible sense, describe as robust case management, the judge put this to Mr. Wazak. I don't think I need to read it out, but the point was, essentially, that the defendant was trying to have its cake and eat it. It was indicating that despite the rejection of the application, it was still going to persist in an allegation that the claimants may have been dishonest, but it wanted the claim to go to the fast track. And as we can see, there was laughter and possibly, I think, a bit of blushing going on. The judge wasn't having any of it. In the circumstances, she allocated the claim to the multi-track. The immediate effect of that was that fixed recoverable costs ceased to apply. The next point is that this claim then, having been a multi-track case, was then subject to the joys of cost budgeting. And whilst we don't need to go into the detail of the budgets, what happened was that the cost budgeting occurred, the judge did it on paper after this hearing. There was insufficient time to deal with it before her, so she dealt with it on paper after this hearing. She therefore budgeted the claimant's case in the full knowledge that the defendants were alleging and were intending to continue to allege despite the rejection of the pleading of a formal case of fundamental dishonesty, that the claimants were on notice that the defendants were going to allege that they were dishonest. So it was no longer a fixed recoverable cost case, and it was budgeted in light of the allegations that the defendants were advancing. The next point to make, if I may come back to the core bundle,
And where are we going with all of this, Mr. Maloney?
well, lady, I'm addressing the point that this is inconsequential absent a finding of indemnity basis cost for the defendants. They get away scot-free. Right. They can make the allegation and there's no consequence. And or that the claimants are going to be seriously disadvantaged because the absence of indemnity basis costs means that the additional costs they've incurred in responding to the allegation of dishonesty is in some way lost to them.
Thank you.
My lady, if you'd assist, I've only got a couple more points, so it will take me just another couple of
No problem. Page?
Page 113.
113, thank you.
So this is immediately following the exchange and the judgment on indemnity basis cost. And so what happens, if we just pick about the fourth entry on page 113, where we have Mr. Buchan, now junior counsel, then counsel for the claimants, having been unsuccessful in his application for indemnity basis costs, he asks the judge to increase the budget to reflect the additional costs that have been incurred in dealing with the allegation of fundamental dishonesty. Now, the judge declines to do so, and in part it's because of a concern that the claimants haven't followed the process for varying budgets. You can see that in the next couple of lines. And then she makes the point in the paragraph in the middle of the page that this matter is better looked at by a costs officer on detailed assessment because the budgets can be varied, the budgets can be departed from if there's good reason to do so. And so the point that she is essentially making there is if you're right about this, if you've incurred costs over budget because of this allegation, go and tell the cost judge, and if he thinks that's right, there's good reason to give you more cost, you'll get them. One point that's made in passing, just to pick up on the previous point I made, we will see in the last 3 entries on that page, Mr. Sharp, for the defendant, made the point to the judge that in fact she'd known all about these allegations when the case was budgeted, so it was already taken account of. And she says yes. So in fact it had already been catered for in the budget, but if the claimants can say that they reasonably incurred additional costs dealing with these matters, and they can persuade a cost judge of that, they will get them. Simply note for the record, over the page at 114, the judge expressed in fact some concerns about costs that had been incurred by the claimants, not least because she had a trial bundle which she described as being an unwieldy beast full of completely superfluous material, which is, I suspect, something sadly this court has to deal with occasionally. The final point I make in relation to these is that whether the claim is on, whether the costs are on the standard basis or the indemnity basis, the cost judge, when considering any assessment, can take into account conduct. That is expressly provided for in relation to considering whether costs are reasonable by CPR 44.43a. The court will have regard to the conduct of all the parties. But just addressing Mr. Latham's concern about proportionality, he's concerned that without an indemnity basis costs award, proportionality may limit the ability to recover costs. But conduct is also relevant to a consideration of proportionality. CPR 44.3, subparagraph 5, expressly identifies that costs are proportionate if they bear a reasonable relationship to ... any additional work generated by the conduct of the paying party. So if Mr. Latham's clients have incurred additional costs by virtue of this allegation of dishonesty, those costs will be recoverable as long as they can show that they are reasonable and proportionate. And that's not just proportionate to the value of the claim. Extra costs can be recovered if the claimants can show they are proportionate to the allegations that we raised. So you could have a low-value claim where serious allegations were raised, claimants spent far more than they usually would for a low-value claim, and on the standard basis they would be able to recover those, provided they could, of course, persuade the court they were reasonably proportionate in light of those allegations.
Well, we have to be realistic, Mr. Mallory. You wouldn't be here if it wasn't perceived that there is a difference between standard and indemnity cost basis.
My Lord, I perhaps should be careful about how I speak to why I'm here, but I suspect I am here more because of the concern about seeking to establish a presumption in all cases of this kind, rather than a concern about the specific additional costs that might be recoverable in this case.
The presumption kicks in, as it's argued, in favour of indemnity costs.
It does.
So so you get back to the same point. I mean, I understand all that you've said, but
yes,
people prefer orders that are couched in terms of indemnity costs.
They do, and of course claimants have a particular eye on that as well because of the escape route from fixed costs, which indemnity costs provides them with.
But here we're out of fixed costs.
Here we're
anyway.
already out of fixed costs. So on the facts of this case, I have to say I'm not sure I would be here if this was, well, I wasn't there on the first appeal, and I'm not sure I would be here if this was a case-specific appeal. But, my Lord, can I also just, on that point, just deal with my client's general position in relation to this? We fully accept that if defendants raise issues of fundamental dishonesty, they put themselves at risk of cost sanctions, whether that's a departure from the budget, allocation to the multi-track, and/or an order for indemnity basis costs. My client fully accepts that if this court says, and we think it speaks already from the existing cases, that if you make an allegation of fundamental dishonesty which is unsuccessful, that is a material factor for the court to consider when deciding whether to make an order for indemnity basis costs. We acknowledge all of that. We, in this case, took that risk. The judge at the end decided it wasn't a sufficient case, but we took that risk. In other cases, if these allegations are made, we will take that risk. Of course, in many cases, these allegations are made and they succeed, but if they fail, we acknowledge that cost risks come with that. What we dispute, firstly, is that this judge erred, and secondly, that there is any need or warrant for this court to depart from what we say is the existing position and apply a positive presumption that, in essence, all that needs to be said is that an allegation of fundamental dishonesty was made, and that essentially switches for the defendants to say why an indemnity basis costs order should follow. We say that's an unnecessary fetter on the court's discretion. We also say that when you do come to look at the cases that Mr. Latham took you to, and I'll come to them very briefly, but for example, in a taxis case, what Mr. Latham seems to think is a presumption that Mr. Justice Bryan applied is a position he only arrived at once he'd looked at the facts of the case. And essentially what he's doing is he's saying, I'm not just applying ab initio a presumption, I've now looked at the facts of the case and said on the facts of the case and what I've seen, I think this is an indemnity basis cost case. Now tell me why not. That's perfectly fine. I understand that and I have no issue with that. But that's different from the court starting from, and this court giving guidance that without proper consideration of the specific facts and circumstances of the case, the mere making of an allegation of dishonesty in any case creates a positive presumption. So, my Lord, my ladies, I'll come back then to the specific issues of this case. One further point we do make briefly at the outset is we do have some concern as to why this case itself is actually troubling this court. I'm very grateful to Mr. Latham this morning for starting off by accepting that this appeal is more circumscribed than it had previously been, and his acknowledgement that the claimants only seek indemnity basis costs from the 6th of May 2021. That was, of course, a concession they made below. It's a concession that they should have brought to the attention of this court when the question of permission to appeal was being considered, and which may well have led to a different conclusion. But we draw a slightly wider point from that, which is that until today, the appellant's case has been advanced on the basis that this judge erred in the exercise of her discretion, in essence, because no judge properly directing themselves could have come to any conclusion other than that indemnity basis costs should have been awarded for the entire claim. The claimants now themselves accept that that should be wrong, that is wrong, but we do say that it reflects on the flaw in the appellant's case, which is to fail to recognise that there were a range of decisions open to the judge. There was not a single decision open to her. There were a range of decisions, one of which included the appellant's case up until today, one of which includes the appellant's case as now presented to this court, and one of which includes the decision that, in fact, apart from for the trial, which were awarded for other reasons, this case didn't quite surmount the threshold in all the circumstances for an award of indemnity basis costs. Milady, I'm not going to delay unduly with the question of the appellate test that this court is exercising. In front of this court, it would very much be a question of teaching others to suck eggs. The relevant extracts are set out at paragraph 25 of my skeleton argument, including an extract from the judgment of my Lord Justice Coulson in the Hislop and Purd case, simply making the point that when it comes to questions of costs, this court always allows judges a wide latitude of discretion, and the discretion could be regarded as being at its widest. In terms of the question of reasons and assumptions, may I just tempt the ire of the court by taking the court back briefly to the Whaley's case. I note the Lady Chief Justice asked Mr. Latham why we were going there, and so I appreciate that I may be putting myself at risk, but if I can just invite the court briefly to go back to it. It's at page 186 of the authorities bundle. And it's a judgment of this court in which my Lord Justice Newey gave the leading judgment. The relevant parts for my purposes are starting at paragraph 21. There's just one other paragraph I'm going to invite the court's attention to. The court's already been to paragraph 21, so I'm not going to read it all out. But the important point at paragraph 21 is this question of the fact that exceptional may, in certain circumstances, be consistent with an application of the test of out of the norm. Now, I appreciate that in that case, Mr. Latham says the factual distinction was that counsel had used the term out of the norm in making their submissions, and the judge had used the term exceptional. Here we have counsel using the term exceptional, and the judge simply indicating that she's applying the test for indemnity basis cost. But in my respectful submission, that is a distinction without a difference.
Well, it doesn't seem to me that that is the context that the Lord Justice Newey was referring to when he said much will depend on the context.
Indeed, my lady.
He wasn't talking about what had been said in submissions. He was talking about the context of the facts of the case.
Exactly, my lady. And that is the point. It is the context in which the term exceptional is used. And if it is, as I've already indicated, the sort of context here, what's being said to the judge is this case is a tall poppy. And the judge is saying, well, I'm not quite sure. In my respectful submission, there is likely to be little in the distinction between exceptional and out of the norm. And I've made the point, but I won't develop it. I've made the point in my skeleton argument that indeed, in other circumstances, the terms are used in an almost synonymous context. For example, in the context of non-party costs orders, where exceptional has been described as meaning outside the ordinary run of cases, which essentially is how out of the norm is used in the indemnity-based context. So context is all important.
Sorry,
Sorry, my lord.
Can you just repeat that? Exceptional equals out of the ordinary run of cases. In what context?
My lord, that's a description of it that's been used in the context of non-party costs orders. It's set out at paragraph 33 of my skeleton argument. So this court, in a case called Deutsche Bank and Sebastian Holdings.
You mean a section 51 order?
Indeed so. Section 51, non-party costs orders.
Yeah. Okay. So paragraph 33 of your skeleton.
My lord, yes.
Very much. Yep.
So again, I don't want to overplay it. It's simply the point that in its context, there may be little, if anything, between the use of the term exceptional and out of the norm or out of the ordinary run. My lady, the second point, just in relation to Whaley's, my lady, if you'll just give me a moment, is the point which is made over the page in paragraph 22 on page 195, sorry, paragraph 21 in page 195 of your bundle. And this is the point taken from the dictum of Lord Hoffman in the Piglowska case as to exigencies of daily courtroom life being such that reasons for judgment will always be capable of being better expressed, but reasons should be read on the assumption that unless he has demonstrated to the contrary, the judge knew how he should perform his functions and which matters he should take into account. That's a proposition that's well embedded in authorities, and it's well embedded for good reason, of course. This very case, a trial judge who's dealt with the matter procedurally as well at trial, at the conclusion of the trial, facing extremely brief submissions and giving a brief judgment in response to those submissions, is the very sort of case. This judge didn't have the luxury of detailed submissions, skeleton arguments, and a reserved judgment. She was giving a brief judgment in response to brief submissions, and in those circumstances, the court should assume that she knew what she was doing, unless it is proven to the contrary. My Lord, could I just briefly also deal with the question of English emery? And there's only a couple of brief paragraphs that I wish to take the court to. It's tab 2 of the authorities bundle, starting on page 19.
But we weren't going to go to English emery. What's the point?
Milady, the point is, well, Milady, I'll rely simply on the extracts in my skeleton.
But I mean, if there's an important point, then tell us what
Milady,
it
no,
is.
in the interest of brevity, if your lordship and your ladyships have my skeleton argument, then at paragraph 26 of that skeleton argument, again, a similar point is made, and I've given the relevant extracts. In particular, I'll pick it up at the second paragraph from the bottom on paragraph 26 of my skeleton argument. Apologies, my lady, I didn't give you the bundle reference for my skeleton argument. It is at
40.
I'm grateful to my lord.
Right, it's paragraph 14 of English and emery.
My lady, yes. And so we have the point, which is that the assumption should be that the judge will have had good reasons for making the cost order that they did, where no express explanation is given. And where it's apparent there's a perfectly rational explanation for the order to have been made, the court's likely to draw the inference that that is, in fact, the reason that motivated the judge in making the order. And what we say in relation to that is that this claimant here knew only too well why their application had failed. Their application failed because the judge simply didn't think that the circumstances in which the question of dishonesty had been raised took this case sufficiently out of the norm. She was given a choice. She was told the circumstances in which this allegation has been made and pursued means indemnity basis cost is appropriate. The defendant said no, it didn't. Without disrespect to either counsel below, the submissions were no more sophisticated than that. And her response was, I don't think it does. Milady, can I then come to...
But it wasn't actually that simple. And we had the standard basis is agreed to the 6th of May, indemnity basis agreed from the 18th of April. So actually it was a choice, but only for part of the exercise.
The judge didn't have that choice. Before her, the point about 6th of May wasn't conceded.
Right.
That concession was only made in submissions to the first appellate judge.
Right. So the judge at first instance was dealing with the costs after the Part 36 offer.
Indeed. So she was essentially being asked to deal with the question of indemnity basis for the costs of the claim.
Okay, thank you.
So it was a relatively stark choice for her. Lady, just in terms of authorities, just so whilst we're on the authorities and before I depart from them, I'm loath to get too far into this issue, but can I just deal briefly with the point about what the authorities do and do not say about a presumption or a starting point? I'm not going to go through all of them.
But
and
this is important. This is, as it were, if there's a principle in this appeal at all, this is the point. So
this is the point.
Don't be shy of the authorities.
Well, Milady, thank you. I'm grateful for that. I'm not sure I should describe this as an encouragement, but that invitation, perhaps. Milady, can I pick it up? Can I come to the case of Clutterbuck, which is paragraph 149 of your authorities bundle? So this is the decision of Mr. Justice David Richards. And so the point that we would make in relation to this is simply that what the judge is doing here is dealing with a question of what the appropriate order is on the case, facts of the case in front of him. But I just need to briefly address the point about the support Mr. Latham draws from this decision as to the reason why there should be a default position, in essence, in cases where fraud allegations have been made. One note of caution I will sound is that these cases almost invariably deal with cases where claims are brought on a fraudulent basis. They are not, generally speaking, dealing with cases where the defendants allege dishonesty by claimants in response to that fraud. And this is directly relevant to what the judge says here, because if we pick it up at paragraph 17, what the judge says is the underlying rationale of that approach, which is the general approach towards indemnity basis costs where a failure of a claim in fraud, the underlying rationale of that approach is that the seriousness of the allegations are such that where they fail, they should be marked with an order for indemnity costs because, in effect, the defendant has no choice but to come to court to defend his position. So this is dealing specifically with the fact that the defendants, they're not the party bringing the claim. They are faced with a claim that they have to defend or settle. They have no choice in that situation. It's not their claim. They are in the position of having to defend. And in that situation, the judge attaches particular weight to that as part of the rationale for placing...
Is that a principal distinction? Because the defendants faced with a claim for fraud have no choice, in brackets, if they want to defend. You could just as well say, couldn't you, claimants faced with a defence alleging fraud have no choice but to proceed if they want to proceed with a claim.
Milady, yes, but I suspect, but I don't know because it's not developed further here, that the underlying concern as to this is the general concern, for example, the concern that's expressed in the Kwaku and Eshore case by this court, about claimants bringing fraudulent claims and the general public interest in seeking to ensure that claimants who bring fraudulent claims are sufficiently discouraged. That is, we say, a different situation from a defendant who says, well, I'm facing a claim. I have a concern here that there's something not right about this claim. There's something iffy about this claim. As Mr. Latham has expressly set out, in that situation, a defendant, if we come back to the personal injury situation rather than the sort of commercial situation, a defendant in that position doesn't necessarily need to plead a case of fundamental dishonesty, but what they are required to do is put the claimant on notice if they might be asserting at any point that the claimants are acting fraudulently or dishonestly. So you have a defendant that's facing a claim, it puts the claimant on notice to protect its position. We say that is a material distinction from the idea of claims that ab initio are brought as a fraud by claimants. And that there is a different policy weight that's attached to those. That's not to say that defendants who do raise the issue may not be at risk on the facts of an indemnity basis court, but that same public policy imperative of preventing fraudulent claims from ever being brought, from taking up the court's time, from taking up resources unnecessarily, is a different one. Milady, may I move on then to the Nataxis case, which my learned friend attaches particular weight to? This is the decision of Mr. Justice Bryan. And if we can come to page 211 of the authorities bundle. 211, Milady. 211, 211. So, paragraph 49, the court's been taken to, which is the discussion of whether there was a starting point in light of the cases such as Clutterbuck. And it was accepted there that there was a starting point, albeit it was said that the court retained discretion. But of course, we need to be careful about what is meant, as the court's already indicated, by a starting point. But what the court then went on to do in that case is the court looked at the facts, and we can see that at paragraph 50 and 51 and 52. It considered the facts of the particular case in light of submissions that were put to it. And it was only having considered those facts that at paragraph 53, Mr. Justice Bryan came to the conclusion that he considered that the starting point is indeed the cost should be on the indemnity basis. So, again, my respectful submission is that what the judge really is doing here is saying that if you can make out on the facts, and here I accept it's made out on the prima facie facts, that there was a claim brought, and again this is a question of a claim being brought on a fraudulent basis, a claim being brought on a fraudulent basis with no good explanation, which of course would be difficult with a claim brought on a highly fraudulent basis, then on those facts, I'm going to say, well, there's a prima facie case made out. I can see that there's a prima facie case for indemnity basis costs. Why shouldn't I award indemnity basis costs? That's not applying a presumption that in any case where fraud is raised, indemnity basis costs should be awarded. It's simply saying there's a good case made out for indemnity basis costs. Why shouldn't I give them?
Natixis, Naxis, whatever you want to call it, hasn't been reported anywhere, has it?
My lady, I don't think so. I assume not. It's my learned friend's case, but I assumed if there was an authoritative report of it, it would be in the authorities. And my lady, that then takes us on to, I'm not going to go through all of the other cases, I'm simply going to come to the judgment of Mr. Justice Miles in the Libyan investment case, which is page 267 of your bundle. And in fact, I'll just take your ladyship straight onto page 268, paragraph 9, which you've already been taken to. And my respectful and short submission on this is if we strike out the errant or in the third line, this is an entirely accurate summary of what the position both is and what it should be. There's no automatic rule. There's no starting point in the sense, and it is important qualification that is put. Unlike the other cases, here Mr. Justice Miles goes on to make clear what he means by a starting point. There's no starting point in the sense of what I would describe as a presumption, simply because an allegation of fraud has been made and failed, even in the context of a fraudulent claim, let alone in the context of dishonesty being raised as a defence. The default position is standard costs. But obviously, any raising of the issue of fraud or dishonesty is the factor for the court to take into account. That is, if this court is to give guidance, in my respectful submission, it could give little better guidance than endorsing the dictum of Mr. Justice Miles. So our submission is no starting point in the sense of a presumption, a complete discretion, but must take into account all relevant factors.
Could there be a starting point in some other sense than a presumption?
Well, my lady, I'll come back to what I say was the exercise conducted by Mr. Justice Bryan in the Taxis case, which is that if a court says, I've considered all the facts, I've heard your submissions, I consider the facts and circumstances, or I've heard your initial responses, and I've considered the facts and circumstances, it seems to me actually here your client's conduct was pretty egregious. You're going to have to go some way to persuade me you shouldn't be facing indemnity basis costs here. Well, that, to some extent, that's a starting point. I can see that point. On the particular facts, I, the judge, have reached the conclusion that prima facie you're in indemnity basis.
No, well, that's what you say Mr. Justice Bryan did.
Yes.
In the Naxis case.
And you, Mr. X, have got to row me back from that point. Well, I can see that as being described as a starting point. But a starting point in the sense of the court simply saying, dishonesty was raised in this case. Whichever side it was raised by, whatever the circumstances were, dishonesty was raised in this case. Therefore, it is indemnity basis costs, unless you persuade me otherwise. In my respectful submission, goes against the authorities. It goes against principles that have been established. And the fundamental point, it's not necessary. It's just not necessary, because in any given case, if the facts on proper consideration warrant it, indemnity basis costs will be awarded. Milady, may I just deal, I'm going to turn to the judgment. I've got my eye on the time. I can't guarantee I'll finish within 5 minutes.
No,
but,
nobody's asking you to finish by 1
I'm
o'clock.
grateful. Milady, can I just deal briefly with one point that Mr. Latham didn't really attach any weight to, so I will deal with it briefly. Not least because it was a point that I think the court had in mind from an early question. It has been said, as part of the appellant's case, that one of the errors the judge made was not to take into account that my client had been dishonest. It was never put to my client that my client had been dishonest. Unsurprisingly, it was not found by my client, by the trial judge, that my client had been dishonest. The trial judge was never asked to make that finding, and she didn't make that finding. Furthermore, it was no part of the submissions made by the claimant's counsel to the trial judge that my client was or should have been found to have been dishonest, and that was a factor she should take into account when deciding whether to award indemnity basis costs. So at every stage, the suggestion that the judge erred because of failing to take into account that my client had been dishonest, it's a point in my respectful submission that should never have been raised as part of this. I'm not going to develop it any further unless it would assist the court to do so. I can, if it would assist.
I do apologise, excuse me.
Lady, may I then come back to the core bundle and to page 112. These are the submissions that were put to the judge in relation to this issue. And we do say that this is important. The submissions of claimant's counsel are a single paragraph, and they consist essentially of saying that the spectre of fundamental dishonesty has been, we don't know what the missing word is, but probably something along the lines of raised, and it's not been abandoned, and it's been hanging over the head of the claimants. Now, those, of course, are matters that the judge knew as well as anybody. And then, in terms of costs, it's explained that senior counsel had been instructed. Of course, that was a matter that the judge knew about at the CMC when she was setting the budget. And therefore, it said indemnity basis costs should be awarded because of the way the defendants have defended this case. Now, one of Mr. Latham's criticisms is that the judge focuses on the defendant's conduct. Well, the first point I make in response to that is what really is there outside the defendant's conduct that the judge should have focused on? And no disrespect to Mr. Latham, who is an exceptionally capable advocate, but in my respectful submission, when he was asked that question by this court, he was in some difficulty in really responding to that point. But in any event, it's unsurprising that the judge focused on the defendant's conduct because she was asked by the claimant's counsel to award indemnity basis cost because of the defendant's conduct. Lady, the second point that we make in relation to this is that Mr. Buchan, of course, doesn't, as claimant's counsel, set out for the judge the test that she should be applying. But more pertinently, when Mr. Sharp makes his submissions, Mr. Buchan doesn't correct anything in those submissions. He is given the opportunity to do so, as we see in the 2 lines above where it says see separate transcript for judgment. Anything else, Mr. Buchan? And Mr. Buchan does make a further point, but he at no stage says, hold on a moment, Mr. Sharp has just mentioned exceptional. It seems to me he's asking you to do something other than apply the test that should be applied. Of course, if Mr. Buchan had thought that the judge was being asked to or was about to apply the incorrect test, he would have had a professional obligation to say to her that you are applying the incorrect test. He doesn't do so. In my respectful submission, that is likely to be because, in the context, everybody understood what the judge was being asked to do and understood that Mr. Sharp's references to exceptional were in the sense that this case didn't stand sufficiently outside the norm of the other cases. Lady, I see the time. I'm
That's a convenient moment for you. I think it is for us as well. Thank you very much indeed. Are we on track time-wise?
Lady, very much. I doubt I'll be any more than probably 20 minutes.
All
half
right,
an
then
hour
we'll
at
come back
most.
at 2 o'clock. Is that all right for you? Thank you all very much.